Hello everybody, this is Leland the Realtor, and in this video we are going to cover loan contingencies. This video is for informational purposes only. If you have any questions, please consult your realtor or your lawyer. And again, this is in supplement to consulting with your real estate professional if you are in fact using these forms and purchasing a property in New Mexico. So if you scroll down to through your offer to page 5 of paragraph 6, financed or cash purchase. A large majority of this will be getting loans, whether it be conventional FHA, VA, or other type of loan. It is important to specify which one because each one of these loans has their own specific kind of appraisal that they're going to use, and that does matter. This part 1 right here is very important because it lets the seller know if they have made written application for a loan or shall make an written application for a loan no later than blank days after the days of acceptance. Now, the reason for that is buyer shall provide seller with pre-qualification letter from lender no later than X days after date of acceptance. And the pre-qualification letter must meet these specific contingencies. If you do not apply within that period and provide a pre-qualification letter within that period, typically 2 or 3 days, sometimes less, it's a good idea to present it with the offer. But if buyer does not obtain a pre-qualification letter within the time frame stipulated above, this agreement shall terminate and earnest money, if delivered, shall be refunded to the buyer. So it just means at that moment that the contract is now terminated. No warning, it just automatically terminates. So if there's a backup offer on that home, they are now able to accept that backup offer. So it's extremely important to have your pre-qualification letter and be pre-qualified for a home prior to making an offer, because of course you can lose that home. So number 3 right here, if buyer changes lenders after delivery of a pre-qualification letter, buyer shall have the obligation to notify the seller in writing and provide a new pre-qualification letter to seller within 2 days of changing the lender. This is important. The seller needs to know who you're qualifying through and what contingencies that you need to fulfill, because that is part of this contract, and financing is the only, for most people, is the only way they're going to be able to purchase a home. So if your financing falls through, they need to put their home back on the market as soon as possible for someone else to purchase a home. Now, if the buyer does not obtain and deliver a new pre-qualification letter within 2 days of changing lender, the seller has the option to terminate this agreement. If seller elects to terminate this agreement, earnest money, if delivered, shall be refunded to buyer. So remember, the seller in this situation does have the option. If you do not deliver that new pre-qualification letter within 2 days, the seller can say, okay, I don't want to sell it to you. There's a better offer, a better backup offer over here. I'm going to go ahead and take that offer. So again, very important to meet these deadlines. So number 4, buyer shall cooperate and act in good faith in obtaining a final approval for the loan as outlined in the pre-qualification letter referenced in paragraph 6A, number 2, which is right here. If, after issuing the pre-qualification letter, lender makes changes to the loan conditions and or loan program that adversely affects the buyer's ability to obtain a loan, increases the seller's costs, or delays closing, buyer shall have the obligation to notify seller in writing within 2 days of such occurrence and to include a copy of the lender's requirements with a notification. In that event, within 3 days of receipt of the seller shall notify buyer in writing of a seller's approval of such changes, or if seller's decision to terminate the agreement. So if you need to change your loan or change if the buyer needs to change the loan for any reason and it changes the requirements of the loan, you need to deliver that information to the seller. It's for the seller to make a decision. The seller may say, okay, we can continue to go through with this purchase, or in fact, terminate the agreement and accept a backup offer or put their home back on the market. Now, it is important to also notice that if seller terminates the agreement per this subparagraph 6A4, which is this paragraph we're reading right now, earnest money, if delivered, shall be refunded to the buyer. So the seller is in fact not entitled to the buyer's earnest money if they meet all these requirements. If seller fails to notify buyer of seller's position within 3 days of the receipt of buyer's acceptance, seller is deemed to have rejected such change in the lender's requirements. In this event, agreement shall be terminated and earnest money, if delivered, shall be refunded to buyer. So sellers, it is important to notify the buyer that you have in fact accepted the change in loan. If you do not notify the buyer within 3 days, it automatically terminates the agreement, and the buyer's going to go off buy another home, or you're going to need to put your home back on the market.
Okay, another extremely important item here is item number 5. So you definitely want to read this very closely, especially as a seller. In the event the lender determines the buyer does not qualify for the loan, buyer shall provide to seller, and seller must receive a written rejection letter from the buyer's lender. So if the bank needs to write a letter to the buyer that states they do not qualify for the loan, and they need to send it to the seller prior to 11:59 p.m. the day before, or blank number of days before settlement signing date or your closing date. In the event seller does not receive such rejection letter within the time frame set forth in subparagraph 6A5, which is right here, buyer shall forfeit his earnest money if delivered to seller. So this is really important, because if the buyer gets a letter of rejection from the lender saying they cannot purchase the home, the buyer must notify the seller and say, hey, I cannot purchase the home. And if the buyer doesn't notify the seller, they are going to lose their earnest money. Now, there is a little bit more to this loan, specifically the appraisal. So if you want to learn more about appraisal and what happens if a home does or doesn't appraise, or if it appraises for too much, watch my video on appraisals. Again, this video is for informational purposes only, and you should go to your realtor or lawyer for advice when it comes to purchasing a home. This contract may not fit your specific situation, so please refer to your lawyer or realtor. Thank you, and have a really wonderful day.